Let us pray. Almighty God, we give you thanks for giving us another day. We ask your blessing upon our nation. Bless the work of the members of this House. May they work diligently to bring about solutions to the pressing issues of these times. Bless all men and women across our country, especially those who work in the service of others, especially members of our police, medical personnel, and members of our civil service. May all that is done this day be for your greater honor and glory, through Jesus Christ our Lord. Amen. Say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, or forgive us our trespasses, as we forgive those that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
This House is in session. Minutes of the meeting held on Friday, June 7th, 2024 to be deferred. Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
Questions of the aforementioned minutes be deferred. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The aforementioned minutes are hereby deferred.
Announcements by Your Honour, the Speaker. Messages from Her Excellency the President. Petitions, papers, government notices, private members' notices, notices of questions, reports from select committees, first readings of bills, statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honourable Leader of Government Business.
Mr. Speaker, I beg to move the suspension of Standing Orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
The question is that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business, sir.
Government business is the order of the day.
Order number 5, in the name of the Honourable Attorney General and Minister of Legal Affairs, to move the second reading of the Criminal Procedure Amendment Bill 2024.
Honourable Member for St. Joseph.
Mr. Speaker, today's bill requires us to look in some modest detail at the reform of the criminal justice system in Barbados. Barbados has always had a proud history of following the rule of law. It has had a proud history, sir, of having institutions, especially those associated with the criminal justice system, that operated efficiently and very much to our credit. I can think of course, the judiciary, the police service, probation department, and others. There is no doubt, though, that as we have advanced as a society, the criminal justice system has been required to carry an increasing amount of the weight of some of the dysfunctional side of our development. Yes, Mr. Speaker, we've done very well over the years in terms of healthcare, in terms of education, in terms of social services, and all of these indices, Barbados has done well. But our society has perhaps become a little fractured along the way, and therefore we are seeing, Mr. Speaker, an increased involvement among our young people, especially in the criminal justice system. I remember growing up, sir, just under Charles War Bridge, at a time when Buddy was the menace to the Barbadian society, Buddy Braffett, a man from Ellerton, I believe. So that would give you an idea of what I'm talking about, sir. And even though we had people like Buddy Braffett throwing dynamite at police and running police and all kind of thing, there was no feeling, sir, that our society was beyond redemption. Our societies were still cohesive. In those days, we had youngsters who would get off the bus in Charles War Bridge, but who seemed to have a feud against the men from Ellerton. So the moment they get off the bus, rocks would rain down on the bus as that bus headed up to Ellerton, and vice versa. We look back on these things now almost as part of Barbadian folklore, and we think, what a wonderful society we lived in those days. Perhaps when history consigns the 2020s into the distant past, we will probably find some folklore associated with this present moment. I hope so. But what we do have, Mr. Speaker, is unfortunately a situation where, because of the inefficiencies of our criminal justice system, Barbadians have begun to doubt whether it is effective in helping to deal with the challenges that we face. You know, Mr. Speaker, one of the greatest things that will weaken, or one of the things that will weaken a society's resolve more than anything else, is when that society begins to lose faith in our institutions. And there have been a number of things, sir, in the last few years that I think have caused Barbadians to wonder whether the system, the legal system, the criminal justice system, is working in our favor. You only have to think about the revolving door that is Glenderry, or Dodds. You only have to think, sir, about the fact that people have been able to get out on bail who are on multiple homicide charges, things that never used to happen before. You can reflect on the fact, sir, that as you open the daily papers or the daily paper, cases are being brought up to be tried for incidents that took place 10 and 15 years ago. The memories of the witnesses have grown dim. And you have to ask yourself whether justice is being served by trying to stretch somebody to remember exactly what happened at 2 o'clock in the morning in the year 2007. I perhaps can hardly remember what happened 2 o'clock in the morning a year ago. Mr. Speaker, we came to this government in 2018 resolved that we would do whatever is required to deal with the inefficiencies and the inadequacies of the criminal justice system. Let me share with you, sir, some numbers, and you can find these numbers in the reports of the Judicial Council. The statistics I'm going to share, sir, are filings of criminal cases on an annual basis for the last decade. Now, by filing of criminal cases, I'm really saying matters that have been presented to the High Court for trial on indictment. This has nothing to do with the many magistrates' court cases. We're just talking about the High Court and matters on indictment. In 2013, sir, 187 matters were filed on indictment. 187. In 2014, 245. In 2015, 70. 2016, 149. 2017, 386. 2019, 301. 2020, 219. 2021, 307. 2022, 184. And 2023, 72. This statistic is not offered to suggest anything to do with the level of criminality in our society, because as you know, sir, this is not a statistic relating to criminal activity, only to filing the indictment in the court, because an offense might have been committed, let's say in 2014, but the indictment is only filed for any number of reasons. Maybe the investigation is not complete, all kinds of things, but the indictment may only be filed a few years later. So this is not a reflection of criminal activity, this is only a reflection of the act of the DPP of preferring an indictment. But those figures, sir, add up quite quickly to well over 1,000. And these are cumulative, there's a cumulative effect, because in any 1 year, only so many matters will get disposed of. So you're adding year on year to the number of criminal matters that are available to be tried. When we came to government, sir, you well remember that there were 2 High Court judges. 2 High Court judges. Now, sir, in 2017, I told you that 386 matters were filed in indictment, and in 2018, 203. You only had 2 High Court judges. So in those 2 years, sir, you had just shy of 600 indictments filed in the High Court, just those 2 years, but only 2 High Court judges to try them. And that's just a snapshot of 2 years. That does not rake into the equation those you left undone from the previous years. It was obvious to us, Mr. Speaker, that the first thing that we had to grapple with was strengthening the judiciary. Strengthening the judiciary. And we immediately set about changing the Supreme Court of Judicature Act to increase the number of judges. And I should also remind you, sir, that in 2018, we had the practice of not having a full-time criminal division. So, as you well know, Mr. Speaker, a particular judge will be doing assizes at a particular point in time. After 3-4 months, they've gone back to be doing family or civil or whatever it is. That weakness, of course, meant, Mr. Speaker, that a judge really could not develop the level of expertise that he or she needed to develop in the criminal media, simply because they would be in the criminal media for a couple of months and then you're gone. You may get rotated back in 2 or 3 years. That was a weakness in the system. I can tell you that as far back as when Sir David Simmons, I apologize for calling his name, but it is not in any demeaning way. Former Chief Justice Sir David Simmons implemented 2 initiatives. One of them had to do with removal of committal proceedings. Now, sir, you've been involved in all committal proceedings, and you know a committal proceeding can last for months, if not years. We've moved to paper committal, which means that the magistrate gets the papers and makes a decision, and it moves into the system faster. He also abolished the assizes, and so we now have continuous assizes. But those things of themselves, while they were helpful, they were not successful, sir, in breaking the backlog of the delays and the increasing number of cases that were stacked up waiting to be heard. So that's why our first initiative has been and was to increase the number of judges. But we also codified the concept of a criminal division so that a judge is appointed to the criminal division. That is where you sit, that is where you work every day. You're not going to be doing family come December. You're not going to be doing civil matters come December. You are in the criminal division. And you work in the criminal division. That was an important initiative. But instead of just having 2 judges and the permanent complement of the criminal division, we increased that to 3. And then we doubled down, Mr. Speaker, by appointing 2 further temporary judges. So we effectively moved, in 2018, the number of judges doing criminal matters from 2 to 5. We had COVID, and that impaired a lot of what was happening, but even during COVID, I have to compliment the judges, they still managed to get matters moved through the system. In 2022, sir, we increased the number of judges even further by appointing a further 3 criminal judges. So in the short space, Mr. Speaker, of 4 years, we increased the criminal bench of the High Court of Barbados from 2 judges to 8. Now, Mr. Speaker, we are seeing the benefit of that increase every single day. Yes, we still have challenges, but the number of matters that are moving through the criminal bench is phenomenal when compared to when we were just limping along with 2 judges. What else did we do, Mr. Speaker? We've agreed to the establishment of a post of Deputy Registrar Criminal Division. And the Ministry of the Public Service is busy trying to complete that recruitment. And the purpose of that registrar, because if you have so many cases moving through, somebody has to manage the pipeline. In the same way that we have masters in the High Court and registrars. We've determined that a registrar criminal would be the individual who is responsible for managing the pipeline of the criminal division and help to take some of that admin work off of the back of the judges. We increased the number of judicial assistants, Mr. Speaker, and that helps to take pressure off of the judges as well. We've also introduced new technology called voice rating to replace the transcription that we used, and we still use it. Now, for those people who would not know, judges used to write down every single word that was said in court. So if you have 8 days of testimony, everything that is said, the judge had to write down longhand. Every single word, a most torturous exercise. And if he wrote badly, I could never be a judge, sir. Because I can't even read my own handwriting sometimes. But those were the realities that we had to face. And then somebody had to go and sit down after the trial and type out all that evidence. It was a crazy system, but it was what we had. And then we moved to transcription where, you know, the individuals would, it's the kind of thing you used to see on Perry Mason, the person with the stenographer would sit there and type up the thing, and you would have it available to you immediately. But we've changed that now, sir, and we're transitioning to something called voice rating, which is a new technology, but very much in vogue and used across the world. And we have increased the number of individuals in the transcription exercise from 15 to 37, sorry, from 15 to 27. 27, from 15 to 27. So, sir, we're doing, I mean, obviously you appoint more judges, so you need to have better transcription services. So we've taken a lot of initiatives. But, sir, what was obvious to us was that as an administration, while the responsibility was ours, we had to have a sensible dialogue with the stakeholders. We had to have a sensible dialogue with the stakeholders. And, Mr. Speaker, last year in May and June, we had a 2-day criminal justice symposium. It was participated in by judges. The bar was the heaviest set of participants. We had civil society, we had the government side, we had the police, everybody who had an input, probation, all of them, who had an input into the criminal justice system were invited to be and participated in that process, sir. The churches were there. And the churches asked, well, we'd be happy to come, but why invite us? We said, because you have as much a stake in this as we do. So we want you to be a part of the process, because you are either going to be involved in keeping people away from the system, helping to counsel people who are in the system, or helping people to adjust when they're on their way out of the system. So we had the churches, everybody came to this symposium. Mr. Speaker, we had a number of papers presented. It was really a very good session, a very good 2-day session. It was rough along the way because the bar didn't pull any punches. The DPP didn't pull any punches. The only people who I think pulled punches were the judges who, by convention, are not inclined to be combative in public arena. But that particular symposium, Mr. Speaker, allowed us to focus on what the issues are and to help to form a consensus on what improvements were needed. Mr. Speaker, there are a variety of things that the symposium gave rise to, that we needed new criminal procedure rules. Those have been completed by the Law Reform Commission and have been sent to the Bar Association for comment. So that is moving along. We expect that work will complete by the end of summer, and by the start of the new court year, we should have new criminal justice rules. And just for completeness, let me say, Mr. Speaker, that even though we're putting those rules in place, we're not putting them in place without training. My ministry has already committed to funding the training that is necessary. Mr. Speaker, if you show up in court in September, October, and you know how to deal with new rules, well, you got to spend as much time working through the rules as you do preparing for your case. That's unfair to everybody. And therefore, we want people to be engaged in working through the rules, getting to understand how they work, both on the government, the DPP side, and the private bar and the judges, so that these new rules become a benefit to the system. We're also going to be introducing plea bargaining legislation, Mr. Speaker. This is another initiative that we felt was important. Right now, we have no structure for plea bargaining. There's no structure for it. You can hopefully convince the DPP to offer a lesser charge if the person plead guilty, but there's no structure, there's no teeth to it. There's nothing that you can hold somebody to. So DPP may say, are we withdrawing these charges and we're going to bring new charges, and then the fellow says, still say not guilty. And what have you done? So that is another mechanism that we're going to put in place. That legislation the draft is virtually completed. I expect to be able to certify that within the next 2 weeks or so, and then it will come here for laying. But today, sir, we're dealing with judge-alone trials. Judge-alone trials. I'm happy, sir, to say at the outset that two very strident voices, people who are able to speak authoritatively on the behalf of the Democratic Labour Party, have come out and supported the judge-alone trials. But I'm not surprised, because both of them were present at the symposium, and they participated fully in the discussions, and they gave the imprimatur to the decision of the symposium to bring judge-alone trials into the system on the condition that accused persons would elect. So I'm happy to know, sir, that on this particular matter, I believe that some people from across the aisle are supportive of it. We will wait to hear what the official position of the official spokesperson of that party is today. This legislation that we have brought, sir, is intended to help the system be more efficient, and there are a number of advantages. One of the advantages, and sir, we're not inventing the wheel here. Across the region, Trinidad has judge-alone trials. I think there are a few other jurisdictions that have them in the region. They've been working very well. And the judge-alone trials, the first judge-alone trial I think Trinidad had came during COVID, and it was a murder trial. Fella got off on a murder trial. So it is something that is tried and proven. But the history of it, sir, is worthy of we can't just gloss over it. Going back as far as the Magna Carta, sir, it has been a foundation principle that a man should be tried by a jury of his peers. He should be convicted only by a jury of his peers. That's probably the better way of expressing it. And sir, that has been one of the pillars of our criminal justice system. Of course, sir, that rule does not apply to the magistrate's court, where every day, all across Barbados, magistrates sitting alone determine innocence or guilt, sometimes in matters that are fairly complex. You remember only too well, sir, that many of a matter is triable, as they say, either way. So the accused gets to decide, do I want to be tried for this offense in the magistrate's court, or do I want to be tried for this offense in the High Court? Same offense, sir. Same facts. Same offense, same facts. But he can elect whether he wants to do it in the magistrate's court or in the high court. If he does it in the magistrate's court, his guilt or innocence is determined by a magistrate. There's no jury. There's no jury. If he does it in the high court, there's a jury. But the point is, sir, I'm trying to establish in the minds of the chamber and the minds of our listeners that we currently have a system where innocence or guilt is determined by a single arbiter in the absence of a jury. And nobody has complained that justice is not being served. So it is not so alien a concept to us. But in the High Court for indictable matters, a trial by a jury of your peers is something that has been axiomatic. Now, sir, I was talking about the advantages to the system of jury trials. Sorry, to having judge-alone trials. One of those areas, sir, has to do with the fact that typically judge-alone trials are faster than trials with jury. They're more efficient than trials with jury. They eliminate at the outset the selection of the jury. As you well know, sir, when you begin your case, the first thing you have to do is to empanel a jury. And you know what that is like. The system of objections to jurors, all of those things have to be gone through. No, I wouldn't suggest at all that our system is anywhere like the one with the President of the United States, where that took almost a week. But it still takes time to empanel a jury. And of course, the jury system is also going to be coming up for review very shortly. Cabinet will, either this week or next week, have the opportunity to weigh in on the policy decisions. But the point is, sir, that with a judge-alone trial, you eliminate that apportioned time for the selection of a jury. But it also eliminates a lot of the time that you lose when you have voir dires and so on, where the jury has to go out and you make certain decisions. All those kinds of things you get rid of. And of course, sir, you get rid of the fact that there's no jury to retire to come with a verdict. So judge-alone trials are typically faster. They're also less expensive. Now, sir, I can tell you, I've received a complaint recently about from a commercial enterprise in Barbados where one of their senior staff was on jury duty and was on jury duty for a period of about 4 months. 4 months away from the workplace. No, it may be, I'm simply trying to suggest that jury trials take up a lot of resources. They take up the resources of the individuals who have to leave their workplace and come and sit on a jury to determine innocence or guilt. I'm not suggesting at all that that is not a valuable exercise. I'm just saying that it is an expense that has to be factored in. We, of course, pay the jurors so little for serving on jury duty that I wouldn't even want to presume to suggest that that is a saving. In due course, I'll be asking the Minister of Finance, though, to agree that for those individuals who serve on the juries, that we should pay them a little more, sir. I think the current amount of money they get is $10 a day. I don't think the Minister of Finance heard. If you don't mind, sir, say a little louder. The current amount of money that a juror gets is $10 a day. And you sit and you show up at the court in time for 9 o'clock. And you sit there until 2 o'clock in the afternoon, $10 a day. It's probably like $1.08 an hour. So we have to consider, sir, you have to consider that needs to be looked at, but I will make that petition another time in another place. But there's the savings that you get from that, sir. In addition to that, sir, the benefit of a judge-alone trial is that you have the expertise of the judge. Now, sir, it is a difficult marriage, and I know you see it every day. When you have a complex case, and even if it's not a complex case, trying to explain to a juror These are matters of fact on which you get to decide. These are matters of law on which I get to decide. And sometimes my decision on matters of law will influence how you can consider the matters of fact. You really have a system that has some built-in complexities. How many times, sir, have you seen a judge struggling to deal with the issue of corroboration? You don't have to corroborate, but if you don't have it, it's unsafe. And the poor juror trying to figure out what he just said. It isn't so easy, sir. And therefore, because judges are legal experts and have a firm understanding of the law in circumstances where the jury has none, you can get a sounder decision coming from a judge alone in those circumstances. But sir, the one that I think would immediately resonate more with individuals is the effect of bias. And I don't mean bias in the legal sense. I mean bias in the sense that jurors are human beings and they take into account, for better or worse, things that when you look at it, you say to yourself, how is this fair? So imagine a clean-cut young man who shaves and so on, and he looks very decent, and he got on his Harry Potter glasses, and he goes before the jury, and when the jury says, oh, he looked like Alfred that he used to teach in Sunday school. He was a nice little boy. Those are the kinds of things. Those are the kinds of things that will come into play, which have nothing at all to do with the evidence, nothing at all to do with the evidence, but jurors develop a unique perception of things sometimes from the very early. But equally, a fellow who might be totally innocent comes into court, but he look a little thing, and a juror says, he too ugly though. And immediately, there's almost something coming through you to you, Mr. Speaker, where you say, oh Lord, this fella, that particular juror, he don't like my client at all. And you can sense it. And therefore, sir, while it is possible for judges to have that kind of attitude too, they're better able, Mr. Speaker, and this is established, they're better able to put those things aside and to make a dispassionate decision on whether something meets the burden of proof and the standard of proof that is required. No, sir, there is the downside. There's the downside. Sometimes jurors have a keener sense of societal issues than judges might. I believe that we are past the days of our judges coming only from the cloistered environment of the upper class of Barbados. But the fact is that, people who are serving on the bench are not necessarily people who stop in Baxter's Road at night, or who go in Oystins for a fish cutter, or who can stop when the fellas gambling on your street light and have a chat with them. So a judge alone trial will have the downside of eliminating some of the diverse social perspectives and experiences. But equally then, sir, you say that the juries can be biased, but sometimes the judge can be biased too. There was a known former Chief Justice of Barbados of some renown who, I was told, I believe the Deputy Clerk would have been told this too, that he said, now these lawyers here could come and eat at my mahogany, because he came from a particular class, and therefore brought certain intrinsic prejudices with him. So there's a downside and there's an upside, sir. It's important for juries to have a role in the judicial system, in the criminal justice system, because juries have to play a part, and therefore removing the opportunity for them to participate in a jury robs them of that chance to participate in an important exercise. So there's a balance in that. And that is why, sir, perhaps why the decision coming out of the symposium was that we would have a system of judge-alone trials which is elective. Elective. And therefore, in this bill, Mr. Speaker, it provides every person against whom a bill of indictment has been preferred shall, subject to the provisions of this act, be tried by a judge sitting with a jury. So, I'm going to break this down, sir. This act says, you shall be tried by a judge sitting with a jury. So it is establishing that this is your right. This is your right. We're not taking anything from you. This is your right. But we go on to say that it is unless he elects to be tried by a judge sitting alone. So you have the right, the inalienable right to be tried by a jury of your peers. But you also have the capacity, Mr. Speaker, to make a conscious decision. I do not want to do a jury trial. I prefer to have a judge. And Mr. Speaker, I'm sure that in your practice, while you've not had this opportunity before, I believe you would probably be able to think of many instances where you would much rather not risk your client going before a jury. Because sometimes the combination of fact and law becomes so complex that you really wonder whether the jury understands it. And therefore, you may prefer on a very technical matter to rely on the intellect and disposition of a judge alone. So this, I reiterate, reaffirms that every accused person on indictment has the inalienable right to a judge and jury. So it is inalienable in the sense that we can't take it from you. But you have the right, if you desire, to ask for a judge alone to do your trial. Now, sir, the act in itself is not too complicated, but I'd like to highlight that where a person, upon being arraigned, elects to be tried by a judge alone, the court then has to make a decision as to whether to allow that. So the court gets to use its discretion. But in using its discretion, the court must be satisfied that the person has sought and received legal advice from an attorney at law in relation to a trial by a judge sitting alone. So he must have received legal advice from his attorney or from an attorney on exactly what a trial by a judge sitting alone is. What does it mean for him? What does it mean for in terms of his rights? So he gets to make that decision, and he has to file a form. And it is called Certificate of Waiver of Legal Advice, if he does not have legal advice, or Certificate of Confirmation of Legal Advice. So in other words, sir, a person who says, upon being arraigned, I want to elect to be tried by a judge alone, the judge has the power to order yes or no. But should the judge be disposed to order yes, the judge must satisfy himself, sir, that the individual has received legal advice from an attorney in relation to a judge sitting alone. Now, a person may decide to waive, sir. I'm sure you've been in court sitting where a fellow said, I am defending myself. And sometimes they win. Sometimes they win. So an individual who has taken the decision to defend himself, to tell him now that he got to go and find a lawyer to advise him on where to do a judge alone trial really makes no sense. So you have built into the procedure a power of the individual to say, I waive my right to legal advice on this matter. I understand it myself. I don't need to go and pay a lawyer to tell me what I already understand. So the person can waive the right to legal advice, but if they do, they have to sign a certificate. If they get legal advice, they also have to sign a certificate confirming that they have received legal advice. So the matter of a judge alone trial is not one that is done lightly. The Act says, the bill says, the court shall not proceed to try the person by a judge sitting alone unless it is satisfied that the accused person understands the difference between a trial by judge sitting alone and a trial by judge sitting with a jury. That's key, sir. The judge cannot do a trial by himself alone unless he is satisfied that the accused person understands the difference between the two. This is especially important because we want to make sure that no advantage is taken of an individual, sir. Now, the accused person can change his mouth anytime before the trial starts. And this is also provided in the Act. An accused who is elected for a trial by judge sitting alone may withdraw his election before his trial begins and elect to be tried by a judge sitting with a jury. Now, Mr. Speaker, you're well aware of the process. You first go to court and you get arraigned. How do you plead? Guilty or not guilty? And at that stage, he's given the option. I want to do a judge-alone trial, or I don't want to do a judge-alone trial. Now, as you know, Mr. Speaker, the trial doesn't start that day. Trial doesn't start that day. It is then adjourned for trial. And therefore, at any time before the trial actually starts, the accused person can say that I changed my mind, Judge. I want to be tried by a jury. And the judge must allow the person to take that particular course of action. But it may also be the other way around. The person who might have elected to be tried by judge and jury may change his mind, and as long as it is before the trial starts, he can then say, I want to do judge alone. Mr. Speaker, a large set of the amendments here are consequential because we're now talking about adding judge-alone trials. So where you have provisions in the Act which dealt with jury, you now have to make technical adjustments to be able to allow for those things to happen where there is a judge-alone trial instead. The Act itself is not complex. As I said, Mr. Speaker, the decision to do this came out of a symposium on criminal justice reform. It has received the highest support from two ranking members of the Democratic Labour Party, given very publicly. I was very pleased to see that they supported this measure when they spoke to the press about it in the last 2 or so weeks. But in addition to that, sir, I don't want to say took the precaution, I followed the wisdom, Mr. Speaker, of sending the draft bill to the Bar Association and asked that they consider the draft bill and let us have their comments. The criminal section of the Bar looked at the draft bill, they made their recommendations, there were no major issues. Those things that we could accommodate, we did. Those things that we disagreed on, we did them. But there's really no light between us on this particular issue. And when that consultation was finished, Mr. Speaker, and the new bill drafted, the amended bill drafted, we then took it to the Criminal Justice Reform Committee. Now, Mr. Speaker, one of the important institutions that came out of our Criminal Justice Reform Symposium last year was the establishment of a standing committee called the Criminal Justice Reform Committee, chaired by the learned Chief Justice. And that committee consists of two members of the criminal bench, consists of the DPP and the Deputy DPP, the Attorney General and Minister of Legal Affairs, the Minister of Home Affairs, the Commissioner of Police, the Superintendent of Prisons, the head of the Probation Department. Those are essentially the people who are part of this Criminal Justice Reform Committee, and from time to time the committee co-opts people and gets papers and presentations from people and so on. This committee has been working very hard, sir, and a lot of the reforms have been going through the committee. We now have a new chair since the appointment of a new Chief Justice, but I expect that he will take up that particular mantle and move it further forward. But the point I'm making is, sir, that Even after the symposium, and got the policy direction from cabinet, we did the draft, we went back to the bar and said, tell us what you think. They have submitted their views. We have incorporated as many of them as possible. And then we took the bill to the Criminal Justice Reform Committee chaired by the Chief Justice to get its final imprimatur. This bill has gone through a significant degree of consultation, and I'm satisfied, sir, that what we have today, it not only fits the bill, it has the potential, if it is used, and we hope that it will be used by the criminal bar, has the potential, sir, to get rid of some of the backlog in the criminal justice system. And, sir, it has the potential also to ensure that, that we are able to save some costs, even though the cost issue is not a major determinant. I commend this bill to the chamber. It is new, sir. As I said, since going back as far as the Magna Carta, the right to be tried by a jury of your peers has been a cornerstone of the criminal justice system. But we have to look at these things in many perspectives. The perspective of Canada, sir, is that an individual has the right to choose between a judge-alone trial or jury trial. But they express it a little differently. They say that an accused person who does not want a jury trial will not be forced to have one. No, it takes you to the same place. But the attitude of the system is a little different. They're saying, if you don't want a jury trial, we will not force you to have one. We're saying, you have the right to a jury trial. If you want to elect, however, we give you that right. But our approaches are a little bit different. In Australia, jury trials are common, but equally common are trials by judge alone. Let me say one thing on the matter of elections, sir. And no, I don't mean the general election. I mean the matter of electing to choose judge alone trial or judge and jury. Trinidad, when they enacted their legislation, took the approach that we are taking. That is, that you can elect. And by the way, sir, we've decided in our legislation that treason will always be a jury matter. That is a policy decision. Treason will always be a jury matter. And the truth is, I don't know if we've ever had any treason cases in Barbados, certainly not in living memory. The history books don't reveal that, though some people, I guess you would jokingly say that they've been treasonous, but not requiring any kind of trial. But sir, so Trinidad took the approach of having giving the accused the right to elect to have a judge-alone trial. From the outside, it appears to me that Trinidad was not happy with the take-up or the uptake and wanted to go a little further and say, you know what, some of these matters are so complex that we're not giving you any more option. We are saying any of these particular category of matters, you must do judge alone. And that's done in some jurisdictions, sir. For very complicated matters, judge alone, we're not wasting time with the jury on this one. However, when they tried to pass that legislation, sir, there was a loud hue and cry. Or as some people in some constituencies would say, there was a loud human cry. So, whichever you want to call it, sir. A loud human cry or a loud hue and cry. That is what happened in Trinidad. And the bar, civil society, everybody jumped up in arms and said, we're not going to agree that a government can force people to do a judge-alone trial. That should be a matter for the accused. The right to a judge-alone trial, to judge and jury trial, is so enshrined in our psyche that we can't allow you to change it. The legislation was not pursued. That is something that I'm only mentioning it, sir, for what is worth to the chamber. We are not going there. We are saying you have the right to decide how you want to be tried. Mr. Speaker, will it bear fruit? I believe that it will. Of course, sir, I can neither speak for defense counsel, nor can I speak for an accused person. But for sure, sir, this bill does not take away the rights of any accused at all, not in the least. The accused loses nothing by this bill. The accused, however, gets the right to make a judgment call on whether he wants to put his future in the hands of 12 jurors, or 9, whichever it is, or whether he wants to put his future in the hands of a single judge. That is a deeply personal decision. But I believe, sir, that given our makeup on the bench, given the temperament of the judges in the criminal bar, and given the level of expertise that the senior members of the bar will, I think I confused myself, given the temperament and intellect of members of the criminal bench, and given the vast experience of members of the criminal bar, I believe, sir, that we will see that in at least some cases, individuals, accused persons will be bold enough to say, I want to do a judge alone trial. I believe, sir, that justice will be served. And as I said, the first judge alone trial they had in Trinidad was one during COVID, and it was a murder case. And it made sense during that time because empaneling a jury was a near impossible thing. In fact, sir, for the 2 years of COVID, we could not do jury trials. Couldn't do jury trials. And this whole issue of judge alone trials was raised with me back then because we didn't know when we were going to get out of COVID, and we couldn't allow the judicial system and the criminal justice system to grind to a halt. Our judges still worked. Our judges still disposed of hundreds of matters. I think in the first year of COVID, they got rid of over 200 matters, and a similar amount in the second year. So there are a number of factors which perhaps have brought this initiative to the fore, but the most important one now, sir, is the hope that it will help to break the backlog of some of the other matters of the backlog in the judicial system. Mr. Speaker, this administration has received nothing but praise for the initiatives that we've taken in respect of the criminal bench. The appointing of judges, sir, the appointing of additional judges has been of enormous benefit to the system. The only challenge that has arisen out of it is the fact, Mr. Speaker, that the criminal bar now has to keep up. When there were only 2 judges doing criminal matters, the lawyers could say, well, before this judge, before that judge, you control the thing. You control the thing. But now that we have 8 judges on the criminal bench, sir, it's a little harder to do that. And the matters are coming fast and furious. And one of the things that the Chief Justice, twice removed, spoke publicly about was the importance of having additional practitioners getting blooded in the practice of criminal law. We can't tell people what law to practice. That's a deeply personal choice. I myself had a little stint in the criminal arena. The last criminal case I did was representing one of the accused in the Garns murder. Early in Garns, sir. I think I did that case in around from Sweetwater. I did that case, sir. I think it was about 1992 or 1993. And therefore, sir, that is the last time that I set foot in a criminal court. It wasn't because he was found guilty. They were all found guilty, sir. And you would recall, sir, that there were some doughty campaigners in that trial. We had Waldo Ramsey and former Prime Minister, member for St. Philip, former Prime Minister for St. Philip South. He also represented one of the people in that case. The point is that has been last I set foot in the criminal court. But the point is, sir, that with 8 judges, pressure is going to be on the senior practitioners to let some of the juniors face some of the music. That is the only way. That is the only way that they're going to learn, sir. And I know that you have that particular bent, and that you teach them, that you're learning them how to swim. Throw them in the water and then get sure how you can. Justice is still served, and I know that you supervise your juniors, but if nothing else, I want to make a call though for an increase to the number of lawyers practicing at the criminal bar. Because, sir, with 8 judges, we've done all those things. The 8 judges are very comfortable in their various quarters. They have everything that they need. But if we do not have enough lawyers to help us get through the cases, then all of our efforts at breaking the backlog are going to be in vain, sir. Mr. Speaker, I don't know that I can usefully add anything to this discussion. However, I will be available in the wrap-up to deal with any issues that might arise, and I'm therefore obliged to you for your patience and consideration.
Honourable member, you got to move. Honourable member for saying Christchurch South.
I'm obliged to you, Your Honor. When I came here last week, I made the comment, which I will repeat today, that as a democracy matures, we find that debates in this place become less partisan and more philosophical. And today, this legislation again finds itself within that genus of debate. The proposal to give to the accused before a criminal court in the High Court the right to choose for a trial without a jury and by a judge alone. I made some notes, and I didn't intend to begin at the end, but I'm going to begin at the end of my note, and I'm addressing a criminal lawyer. If there are criminal lawyers in Barbados, and Barbadians speak now of the 3 who are omnipresent in the courts, you're one of them, sir. And I observed you during the address of the Honourable Attorney General, and I was wondering what was going through the mind of the Speaker in his other life as a defense lawyer. And in another place, Your Honor, if you were asked, even in the corridors out there, if you would advise your client to go before a judge alone, I suspect, Your Honor, that you would tell him you want a jury. And I say that at the outset. And I do not bring any secrets out of the criminal bar, but over the years, defense counsel have perceived judges as having an establishmentarian bias. And I don't think that is contemptuous of any court. To say that you go to the assizes and over the years, the prosecutor and the judge have always been perceived to work more closely than us defense counsel, the outsiders. Indeed, at the old Corey Street, during several breaks, Judge X would motion to Prosecutor Y, and they would repair into the judge's chamber. And we don't think that they went in there discussing the latest cricket score. Justice must not only be done, but it must manifestly be seen to be done. So we endured a lot, Your Honor, in those erstwhile and heady times. And I give that as a history of the relationship between the bench and the bar, the bench and the prosecution, and the bench and the defense bar. And much as the Honourable Attorney General brings this legislation with optimism, I rather suspect that if he's interested in speedy trials, he may find experience may greet him with the distinct possibility that several lawyers at the bar will opt for their jury. And I leave that to you, sir. I leave that to you. I leave the Honourable Attorney General to your experience. When he sees you in a few months, he may well ask you how it is going out there, and you may say to him that your clients, and I don't wish to personalize this, sir, but I rather, if I had to hazard a guess, I would guess that your clients, sir, in that other place, are going to be continuing with their juries. And I give...
Honourable Member, you are my alter ego. You can see your clairvoyant, Honourable Member, such that you are actually speaking for me in that capacity. Honourable Member, you are very brave, my friend. Honourable Member, you are brave because you are speaking for me.
Well, let us leave you then, sir.
You are speaking for me.
Let us leave you...
In my capacity, not as speaker, but in my capacity elsewhere, Honourable Member.
You have not lost in the passage of years any of your wit, sir.
You're speaking for me.
But let us leave you and go to your distinguished colleagues. And as well-meaning as this legislation is, I rather suspect that in 6 months to a year, the Honourable Attorney General will find that your colleagues, if not you...
Honourable Member, they're also your colleagues too. They're your colleagues, Honourable Member. You practice at that bar also, Honourable Member.
I accept the correction. Our colleagues.
Correct.
The Honourable Attorney General may well find that our colleagues are opting to continue with the jury. And I give another anecdote, which I'm sure has been a part of the experience of your colleagues, if not you.
Not your experience, Honourable Member?
Yes,
yes. Your experience also?
Yes, my experience, okay. My experience. During that thing called a summation, and this is for my colleagues, it is important anecdotally. At the end of the trial, the judge gives his summation, and I'm going to say something about summations as well. Let us say Mr. Olton Springer used to be the prosecutor, and I am the defense counsel, or let's choose the name, some man called Mr. Holder. Mr. Holder, let's go for Mr. Charles Leacock and Mr. Holder. Mr. Charles Leacock is prosecuting, Mr. Holder is defense counsel. And during the summation, the judge has the last word, well, the last word before the jury deliberates and gives its verdict. And he is summing up the case to the jury. And Mr. Holder used to hear this language quite often. The judge would say, no, Mr. Holder would have you believe, and he is saying what Mr. Holder has told them about the evidence, Mr. Holder's assessment of the evidence. And he would use the language to the jury, well, Mr. Holder would have you believe that the man did not see what happened. And then he would say immediately after that, but ladies and gentlemen of the jury, Mr. Leacock is reminding you. And that was the language.
I remember sure it isn't, but then Mr. Thorne, sir? Are you sure?
Let us choose Mr. Holder, sir. He did it with Thorne as well.
He did it with Thorne as well?
He did it with Thorne as well. He did it with all defense counsel.
Is there a particular judge you're speaking of, Honourable Member?
You're not getting me to go there, sir.
I just asked.
You're not getting me to go there. But it was the judge's manner of characterizing the final address of the defense lawyer. He would have you believe. In other words, what he's telling you, I know you don't believe, But he would turn then to the prosecutor in his wig, and he used to wear a wig at the time. Mr. Leacock came very conservatively attired, and he would say, Mr. Leacock is reminding you. So he is reaffirming in the mind of the jury that what Mr. Leacock told you, you should accept, and what Mr. Holder told you, well, you can dismiss that. And that is why I say that judges do come with and I choose to say an establishmentarian bias. Jurors came there and they saw the whole arrangement in the court, and they saw the dialogue between the man in the wig and the other man in the wig, because we never wore wigs. Mr. Leacock was one of the last prosecutors who wore a wig. And the rapport that existed between judge and prosecutor indicated to the jury that that was a team. I'm not bringing any secrets out, but you came there and you felt that the defense, the life of a defense lawyer was a very lonely life. And all that he had to rest on, apart from his client, whether he was guilty or not, was the jury. Because it used to appear the prosecutor against you, the judge has and I'm being very careful with my language, an establishmentarian bias. And we went in there, and sometimes even the marshal in the court, even the marshal used to rough up Mr. Holder.
And Mr. Thorne.
You had no peace. You had no peace in that place. They spoke to you differently sometimes. There was another case of, so it was not only a relationship between the judge and the prosecutor, and sometimes the marshal, although there were some marshals who would whisper to you in the corridor and tell you, don't give up, things ain't looking too bad, don't worry about so-and-so. But the relationship between the judge and his clerk, they were so close. And there was a certain clerk, she's now deceased, and I did a case in her court once, and I addressed her. Instead of the judge and jury, I had to address her. I had to win her approval. And she was from St. Philip. My client was from St. Philip. So I spoke of the virtues of the people from St. Philip, and she felt so good. But the point is, she had a way of influencing the jury. If you said something that she did not like, she swore around her chair and she scowled and she showed disgust. So you had to get on her side. So I once addressed her instead of the jury, because I felt that to win Miss W's favor would stand me in good stead. And I talked about how good St. Philip people were, and the man was from St. Philip. The offense occurred in St. Philip, so I addressed her, and we got on that occasion an acquittal. So all these strategies you had to pursue. But the point I make, Your Honor, is that I know the Attorney General means well, but in 6 months we shall find out. We shall find out how many accused persons elect to go with the judge. Of course, you and I may have observed, or they who do that thing out there on White Park Road may have observed that with the improvement in technology, the judges tend to be a little more liberal these days. You and I traveled that road. They were not very liberal then. They shouted at us. They told us to sit down. They told us all kinds of things. So that, let us see how this goes. Let us see how the accused men in this country will elect. Now, I know, and I think the Attorney General said it, that there are some jurisdictions in which it is not an option, that you will have to go before the court and accept that some trials are judge alone. And the Attorney General would have said it, the more complex trials, and I want to take it further and say financial crimes. I mean, you don't want a jury to sit and deliberate on a financial crime or listen to evidence of a financial crime, hearing numbers and statistics and poring over, in some cases, thousands of documents. You don't want to subject a jury to that, so that it becomes a highly technical exercise in which you would prefer to have a judge, because financial offenses and fraud offenses tend to be highly technical matters. Those cases tend to be decided on the basis of technicalities, the nexus between documents, and if that nexus breaks, it can result in an acquittal. So in a case like that, you would want a judge, you would not want a jury, you would not want to bore a jury. I will come back to summations very shortly, but just to give the public some history of this trial by jury, the right, and the Attorney General did, the Honourable Attorney General did refer to it, but that is a right that is located in the 1215 Magna Carta, the Great Charter of Britain. I think it was King John had been breaking some laws, and the people of England forced him to sign this 1215 Magna Charta. And a part of that Magna Charta, the Great Charter, Magna Charta is just Latin, the Magna Carta, I beg your pardon, the Magna Carta was just a human rights document which preserved the right of freedom to trial by one's peers. And that is a fundamental right that traveled throughout the English common law tradition, Australia, New Zealand, South Africa, India, West Indies, of course, would have gone across North America and Canada. And it takes a bit much for all these parliaments and some of these parliaments to abolish that fundamental right rooted in the 1215 legislation in Britain called the Magna Carta, the Great Charter. But some have done it. Some countries have gone farther than this parliament intends to go today, that some parliaments are saying, look, as much as that has been a fundamental right from 1215 to the present, some parliaments have said that they are going to abolish that right, and that in some cases, particularly cases of financial crime, they're going to abolish the right, so that much as we have the option today by this legislation, some jurisdictions are not given that option. Some jurisdictions are saying, you must have a judge-alone trial. This parliament today is not intending to go that far. This parliament, quite interestingly, is saying, no, we are giving you a right. Rather than taking away a right from you, we are giving you a right to opt for a trial by a judge alone. But I've discussed why I think accused are not really going to go for judge-alone trials. It is fairly ambitious, but based on my professional experience out there, I am not optimistic that in the majority of cases it will come to fruition. I read the legislation this morning while the Attorney General was speaking, and I want to draw his attention to Section 3 of this amendment, which is amending Section 7. And Section 3, 1C, I assume there's an answer and a good answer, but so that we anticipate these things, permit me to read Section 3, and this is 1 capital C. And it says, the court shall not make an order for a trial by a judge sitting alone unless it is satisfied that in the case of a joint trial, all other accused persons have elected to be tried by a judge alone, by a judge sitting alone, and each accused person has filed a certificate in the form as set out in Form A, etc. So that what that is indicating to us is that if you have 4 persons on trial, all 4 must elect similarly. And that the trial will not proceed if one says, I want a judge alone, and the others say, I want a jury, or vice versa. What happens? What happens? Now, in effect, there's a sense in which 4 persons come to trial. One man accepts the new right that he has. He now has a right to say, I want a judge alone. You're telling him this is a right that you now have. But here it is, the other 3 men in the dock say, no, 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 he wants a judge alone, they want a jury. Are you then depriving him of his right? Because if this legislation is saying to him, you have 3 men next to you who want a jury and you want a judge alone, that trial is not going to go on according to this legislation. Now, what does the DPP do? I know you're so eager to answer, sir.
No. I remember you. You know
No,
the
I
answer.
won't. I'm just bringing it to the attention of the learned Attorney General that there must be some resolution brought to this because, and I will say to the learned Attorney General, a lot of these lawyers who come and agree at these seminars, you wait until they get to White Park Road. They agree up in the Hilton when they have the drinks, and when they get out to White Park Road, a constitutional motion. And they may well visit the Attorney General or this legislation with a constitutional motion that says, look, you've given me a right, but now there are circumstances in which the same legislation is depriving me of my right to a judge alone because my co-accused are saying they want a jury. What do you do? Now, obviously, I would think the DPP resolves the issue. The DPP may say to the judge, well, she wants a separate trial. She wants to try 3 before a jury, and she will try that one with his judge alone. But that is not the basis on which you order separate trials. That is not the basis. You order separate trials where the evidence, where the adducement of evidence so allows it, where it is proper and fit and expedient to have a separate trial, so that the separation of trial should not depend on a right exercise to a judge alone and a right exercise to a jury. So that this particular section could become problematic unless there is some section that follows. I was trying to read, but the Attorney General deprived me of the opportunity to read the entire thing by ending his speech rather early. But I invite the Honourable Attorney General to take a look at that section, and determine whether it is not potentially problematic where the same man who drank his drinks up at the Hilton will not go down to White Park Road and bring a constitutional motion in terms of a deprived right on the basis of the incidence of a joint trial. Now, I wanted to say something about this question of speed, and I think the Honourable Attorney General, in bringing this legislation, is concerned about speed, and that speed, I beg your pardon, and that is a legitimate concern because the high incidence of crime is sending a lot more cases to the courts. I want to say, though, to Barbadians that while we tend to be preoccupied with the criminal law and the speed of criminal cases, I still want to remind this chamber and this country that the most pervasive branch of litigation is family legislation. A lot of people still suffer within the family law jurisdiction. A lot of children are not supported. A lot of disputes still exist between husbands and wives, between ex-married persons. The question, as I said, of maintenance, the question of custody, the question of unresolved property, that is more pervasive than criminal law. And I want to say to the government that when we are preoccupying ourselves with criminal law and the administration of criminal law in the justice system, please do not forget family law as an area of some urgency. As I said, a lot of people suffer because sometimes the family court is not moving as quickly as it should. And I used to feel so sorry. We used to do it on Friday mornings. Friday used to be the day for family law. And you would see one judge with a list of 30 cases. How does a judge do 30 cases in one day? Of course, that has been alleviated. I believe there are now about 3 judges in the family division. But while we are legitimately concerned with speed in the criminal courts, let us not leave behind the urgency of the family court. The family court family matters are quite pervasive within the administration of justice. So on the question of speed, I would urge the Honourable Attorney General to pay equal attention to both the criminal division and the family division as requiring some equal attention. On this question of speed, I want to now make a recommendation in the criminal courts. And this departs slightly from the question of judge-alone trials. I've expressed my view on those. I've said that I'm not optimistic that the majority of lawyers will go for judge-alone trials. I thought I would have heard the Honourable Attorney General refer to it, but I am going to dare to refer to it. There has been the question of impropriety, let me put it that way, within the criminal justice system. It is felt that there is potential, that there's space for corruption within the system, within the jury system. I believe it was 1999. I was involved in a case. I'm not going to identify the parties. And while the jury was about to deliberate, or I think during the summation or some part of that case, a few jurors were charged. And a few jurors were charged for accepting a bribe. And obviously, they were looking at the lawyers and trying to figure out how much we knew. Fortunately for me, Winston Hall had escaped. And I happened to be at the inquiry. And I left my hapless colleagues down in the court, all under suspicion, because Thorne was not there. Thorne was beyond the pale of suspicion. And time for a water break. But I believe the Honourable Member for St. James Central was at the Winston Hall. Yes, I knew you were somewhere lurking. And he and I had gone to the Winston Hall inquiry. So he and I escaped the pale of suspicion.
And the famous drug case, Honourable Member?
Yes. Very well-known drug case. And I think 2 or 3 jurors got charged. And that revealed, so that I know the Attorney General, the Honourable Attorney General is very shy and timid on this matter, but it is the reality that there exists the possibility of corruption within the system. And I think that may be one of the reasons, particularly in Trinidad, that may be one of the reasons why they are separating jurors from criminal trials. And Jamaica and the other countries with a gang culture, that the tentacles of the criminal element are not short. And they have been known, and I give you a case, sir, here in Barbados. It has been known that that element has contaminated the integrity of trial. The Attorney General seemed, for one reason or another, not to seem shy about saying it, but the record indicates that there exists the possibility in a very small country, in a country in which Jurors go home at the end of every day's trial. You may be aware, sir, that before your time and mine, they used to sequester them at the YMCA. People left home to go to a jury trial, and they did, in fact, leave home. And they lived at the YMCA during the course of that trial, precisely to avoid corruption, to avoid contamination by accused persons. So that is a rationale for judge-alone trial, to avoid the possibility of corruption. That brings me to my recommendation. If on the issue of speed, Your Honor, I believe that summations take up too much of the court's time. You and I reach the end of a trial. The prosecutor addresses, you address, and you're hoping that what the gentleman out there, Mr. Holder, has said is staying with the jury. So what Mr. Holder cleverly tries to do, Mr. Seal addresses a Thursday or a Friday morning, and when the judge is about to turn and ask that man out there called Mr. Holder to address, Mr. Holder says, Your Honor, or my lord, may I have Monday morning? Because he wants what Mr. Seal has said to be erased from the mind of the jury. Mr. Holder wants to come fresh the Monday morning and hope that what he has said is the address that stays with the jury. And he does an excellent address.
I remember it might be more, I think you're more apt to that, and have done that rather than I did.
Another water break.
Take the water break, I remember.
So,
I think that has been a clever policy or a tool used by you rather often in the criminal arena, I remember. I can recall many times.
they battered us in those early days so much. You go through a trial, and by the time you come to address the jury and the spectators believe that you are as guilty as your client. So that we had to seize whatever advantage we could. But the point is, there were these tactical and strategic devices to influence the jury, and we felt that the way to influence the jury with greater impact and effect was to have the last word. Unfortunately, though, sir, we did not have the last word, because the judge would then come after your sterling address, and he would use those famous words to the jury. Mr. Holder would have you, and his body language, well, Mr. Holder would have you believe that the accused was innocent. But Mr. Leacock is reminding you, and he would point at the jury and say he's reminding you, so that the virtue of the state descended in the courtroom against your client's interests, and you were really up against it. Now, I say that we thought we would have the last word, but unfortunately there is this thing called a summation. And I know in the early days, if you finish your summation, let us say 11 o'clock, a Friday, some judges would do it immediately, would do their summation immediately. 2-3 hours, 3 hours was the average time for a summation. In those days, as the Attorney General said, they took everything in longhand, and it wasn't that long. But when the technology changed and the transcription came, we once had a judge who read over 3 books, all of the evidence he read as a summation. That is not a summation. Summation springs from the word summary. You give a summary of the evidence. What is happening today, and I hope no one across White Park Road holds my views against me, but what is happening today, the prosecutor addresses the jury, defense counsel addresses the jury perhaps the next day, and then the judge says, well, look, I am going to adjourn this case for a few days so that I can go and prepare my summation. Your Honor, I have had one in which we adjourned for 2 weeks. Now, how do you address a jury? And a judge goes away for 2 weeks. Well, I mean, unless you're Mark Anthony or Martin Luther King, what you have said has gone from their minds. And then 2 weeks later, a week or two later, the judge comes back and reads this extensive document called a summation, going through all the evidence. you know, the judge tells the jury, the facts are your province. The law is mine. If the facts are the province of the jury, why must the judge intervene on the facts? The jury has heard the prosecutor on the facts. The jury has heard the defense lawyer on the facts. Leave it there. Leave it there. That is where the contest exists between defense and prosecution. But then the judge intervenes, and he wants a part of the facts too. And during his summation, he says to the jury, well, you know, you are free to reject my opinions on the facts. Now, if you are free to reject his opinion on the facts, why state them? And you laugh because your experience, Your Honor, has been that judges have tended to have and I'm going to be careful again, an establishmentarian bias based on what I've said, and I'm going to repeat it as evidence of that establishmentarian bias, the treatment of the prosecutor in the court as a figure of the state, a virtuous figure, a virtuous state figure. And we, defense counsel, we are associated with the man in the dock. We fighting for him. As they say, we out there trying to get off guilty people. Very unpopular place, a terrain that is not comfortable to occupy. And I repeat, in that summation, Mr. Holder would have you believe, and he throws his hands off, but Mr. Leacock is reminding you. And the intonations, everything about the exercise reveal that establishmentarian bias. But the point is, if the facts belong to the jury, let the facts come from the prosecutor and the defense counsel. Why have a judge adjourn for a week or two and then come back and spend another 2 days talking about the facts? The facts do not belong to the judge. Leave the facts to the lawyers and the witnesses. And that is my view, maybe unpopular with the establishment. But I think too much time, Your Honor, is spent on summations. I think the judge's role and he is the judge of the law. The jury, constituted as a composite whole, is the judge of the facts. Leave the facts with them. You take the law, Your Honor, that is your lordship, rather than give your own interpretation to the facts. That is not for the judge. And as I've said, and I repeat, at the end of it, he says, oh, you don't have to accept my opinion. Why say it? Why express an opinion? You occupy high judicial office. And yet, you expect that what you say will not influence a jury, even against as eloquent as Mr. Holder is, as eloquent as he is. When a juror hears a man of high office, a judge, is he going to choose between Mr. Holder and the judge, and is he going to choose Mr. Holder favorably? Highly unlikely. Highly unlikely. So, in terms of fairness and in terms of time taken on summations, I think that the state, that the parliament needs to intervene on the question of summations. I think a summation should be a summation on what is the law as it applies to the charge, the elements of the charge. This is my view, that the judge's role at the end of a trial should be that of explaining the charge, the legality of it, and the legal effect and the legal impact of the law on the facts that have come before. So he can make reference to some of the facts. Indeed, what jurors have been doing these days, jurors deliberate and come back and ask the judge to give clarification and to give legal clarification. They come back and ask sometimes, well, what is the law in this event or that event? I think that should be the judge's role. But it is not for the judge to become a lawyer in the arena. He should not be down there. He should not be expressing opinions on the facts. And he should not be taking 1 or 2 weeks of an adjournment to prepare it. He's not in the arena. Come and give a summation. Now, I have been so bold as to even suggest that there can be a template of summation, a template that the law is always the law. The law is always consistent. The facts are never consistent. There are no two cases that are alike, factually and evidentially. All cases, all murder cases, are alike in terms of the definition of murder. All rape cases are alike in terms of the definition of rape. And the doctrines that pertain, recent complaint, etc. So the law does not change, the facts change. And if the law does not change, and if the judge is supreme on the law, give him a template. Give him a summation that is short. There's no reason for a judge to sum up a case with one accused over 2 days, having adjourned for a week or two. No reason for that. The lawyers deal with the facts, and they deal with the law, and he or she would reserve the right to address our law. Your Honor, I believe that that is one way of shortening these trials. It will contribute to the shortening of trial. It will contribute to the speed that we are requiring within the administration of justice. A short summation, I go as far as to say a template, so that I know in the old days, we used to regard a long summation as an hour and a half. As I've said before, summations are lengthier now because the judges feel some obligation. They have all this technology, they have the transcript, and some of them they feel this obligation to run through all the facts and the evidence. Not for them. Leave that for measures, seal and holder, but not for the judge. Let the judge stay with the law. Give him a template. Half hour, an hour, at the very most. But not to be descending into the arena and expressing opinions on the facts. That is something that I resent. And I don't think the system is fair. When you have a prosecutor expressing an opinion on the facts, and the judge in high office expressing opinions on the facts, and your experience, sorry sir, the experience of the gentleman on White Park Road, and he will not think that it is coincidental, but there's always that coincidence between the opinions of the judge and the opinions of the prosecutor. Again, I say the judge ought to stay out of the arena. And if you're interested in speed of trial and speedy trial, cut down on those summations, produce a template, and limit the judge to specific directions on the law as that law pertains to stating whether the offense has been committed or not within the four corners of the statute. I believe, sir, that that is something that could be done, and it could be done without disturbing anybody's fundamental right to fair trial. So that is one of the recommendations I would wish to make. I state it succinctly. Modify the law as it relates to summations, make summations less evidential and more specifically legalistic, and restrict the role of the judge. And you will find, sir, that when the addresses are done, that is to say by the prosecutor and the accused lawyer, I beg your pardon, and the defense lawyer, that there should be no lengthy delay, that the judge can do it the same afternoon or at worst the next morning. And if it is a Friday, the judge must come back the Monday morning, because you are aware, sir, that delay of trial is unconstitutional. And I want to say that one is seeing a lot of delayed trial. And delayed trial does not restrict itself to the failure of the state to bring the man to trial, but it includes a situation in which the man is on trial. He is on trial, and there is lengthy delay. There is protracted delay. I say to you, Your Honor, that if addresses end a Friday and a summation takes 2 weeks to prepare, that is quite possibly the breach of a man's constitutional right to trial within reasonable time. The question of reasonableness of time, the question of delay of trial does not end when he is arraigned. It continues throughout the trial. You cannot keep a man in a dock on a trial for an extended period of time. You deprive him of the fairness of his trial. So that, I say all that to recommend to the government, through the office of the Honourable Attorney General, that some fresh look may be made at the question of these summations. Everything within the administration of justice that can be repaired should be repaired. And I recommend, Your Honour, that some repair needs to be done with this question of summations. They're too long, and they take too long to be done. Those were my submissions. Yes, I did look at the question of the Magna Carta. I did say, and I repeat, I noticed that the government has been somewhat hesitant on the question of imposing judge-alone trials. I'm sure that the Attorney General, and I think he would have admitted it, that there are some jurisdictions in which you impose it. You impose it. They will complain about Magna Carta. You will get the constitutional motions. I did argue the point constitutionally in another jurisdiction. We failed because as the world develops, charters like Magna Carta become less relevant, I suppose, in a modern democracy. And threats, the possibility of corruption is as much a threat to democracy as the adjustment of a fundamental right. So that it's always a balancing of things, a balancing of interests and a balancing of rights. So, Your Honor, those are my submissions. The Attorney General must not receive it as unjust criticism when I suggest to him that he can revisit this in a matter of months. I am willing to be wrong. As I always say, I have the right to be wrong. But I suspect that when this becomes law, most accused persons are going to continue with the jury. I suspect so. To express a personal, professional view, I don't mind doing this. As people always say, I take my chances with the jury. And I don't think I'm the only lawyer who will say that. I take my chances with the jury. And this is not to advise the public. This is not to advise persons who come before the criminal courts. But I suspect that that will be the position taken by several lawyers, unless, of course, it is, as I said, something so highly technical like one of the financial offenses that becomes almost like a civil engagement, where you're making submissions based on technicalities. Has there been proof of this element? And for this element to be proved, it must connect to the other element. So it becomes like a civil trial. Unless it is that kind of thing, trials deal with emotions. You know that, sir. Trials deal with emotions. I think the Attorney General referred to the perception or the evaluation of parties in trials by jurors. You know, I used to be so distressed when I heard it said many years ago that Winston Hall would never have been convicted in a Barbadian court. People used to say that. And I then discovered that women say that he's handsome. Yes, that's the emotional content. They used to say that Winston looked so, they used to say he has these dreamy eyes. And when the police officers, Measures Thompson and Boeing, were bringing him up from overseas and he's sitting down between them, the old lady said, Kadir, look at his eyes. He looks like such an innocent little fellow. Now, that is how jurors can be. And a good lawyer like you, sir, will work on them emotionally. I don't mean in the sense that the laughter would suggest, sir. So that there's that large emotional content in trial, and lawyers are not going to give that up easily. As I refer to the case of Hall. Now, in 1985, when I was a few weeks out, I actually did that case. If I kept quiet on this, you would accuse me of false modesty. It was Hall and three confederates of his. Yet, and that was one of the highly publicized cases in Barbados, yet you had Barbadians saying, oh dear, Hall is such a sweet little fella. Dreamy, not you, member for St. Thomas? Well, I'm surprised, a lot of Bajan women were saying that. And when Hall escaped, oh, they used to be rejoicing in some quarters. Hall had a lot of sympathy across Barbados. The point I make, sir, he comes to a jury, and his lawyer begins with that advantage. You really think, Your Honor, that the lawyers are going to give up that advantage? As the Attorney General said, that he looked like such a sweet little fella. And if certain other people come, women too, a beautiful woman comes before a jury, you're crowded with men. That's another aspect of jury trial that you are not going to give up. That gentleman, Mr. Holder, wait, not you, sir, Mr. Holder is not going to give up. Because he sits there, and when the jury is being selected, Mr. Holder rejects, the one out there, not this one, Mr. Holder rejects old men. Anybody over 75, Mr. Holder doesn't want sitting on his jury because old men come to a judgment early. As long as the policeman brings a man into the court and puts him in the dock, the old man say he's guilty. A policeman brought him in, he's guilty. And then the next thing to do is fall asleep for the entire trial.
Only policeman, Honourable Member? You sure it's only the policeman?
No, the policeman bring him in.
No, but you sure it's only policeman that says he's guilty and not other persons too?
All men, I said. All men.
But you sure?
All jurors. All male jurors.
Only jurors, sir? Honourable Member? You sure you only want to say only jurors that do that?
I'm going to stay with what I'm saying. So that these are all the elements that go into jury trial. So that Mr. Holder out there, he rejects old men. So I challenge you to go and look at Mr. Holder's juries. Not one old man. Not one. No man who looks like a security guard. No man who is so clean cut that he could pass for a policeman or a security guard. Well, obviously a policeman can't come.
But Honourable Member, if you're speaking of yourself, don't place
No,
Mr. Holder from.
about the
But
man
Honourable
up there.
Member, if you do not have to place Mr. Holder in White Park, where you can speak about yourself, what you have done, or what you do in the criminal courts, Honourable Member. So you don't have to make reference to Holder in White Park. You can say that Thorn also in White Park, Honourable Member. Yeah, Thorn. Not this Mr. Thorn, but yeah, Thorn.
Let not your heart be troubled.
It's not
Your
trouble
Honor.
at all, my friend, Honourable Member.
Thank you, sir. Let not our hearts be troubled. But those men out there, there is a profile of juror that they will reject. The corollary of that is that there is a profile of juror that they embrace. That they embrace. So that, I know the legislation means well, but as long as you leave the option to accuse men with good lawyers, clever lawyers, trial by jury will have a bright future in this country. And having a bright future, the learned Attorney General may revisit this and have the courage at some point to say, look, this thing isn't working. Let us do like the other jurisdictions. I think South Africa may have done it, I'm not too sure. And impose, in spite of Magna Carta, impose trial by judge alone. If I go on any longer, Your Honor, I will be repeating myself. You smile, and I know why you smile. In fact, you laugh, and I know why you laugh. You're saying, perhaps, well, I wouldn't say what I think you're thinking, but let him come. As I have said, Your Honor, I close as I began. In a maturing democracy, debates become less partisan and become more philosophical. And we are all interested that justice should be done. And we are all interested in how justice should be done. Will this bill do justice to the administration of trials? It is left to be seen. Nobody here is a prophet. We don't know what is going to happen. So that the ability to predict is not also the ability to prophesy. And we shall see what we shall see in a matter of months. Your Honor, I'm obliged to you.
Honourable Member for Christchurch East.
Mr. Speaker, sir, I am glad that the Honourable Leader of the Opposition seemed to almost threaten to perhaps be in support of the legislation. And I'm glad that he chose to stop himself, sir, before, in his words, he went on so long as to start to repeat himself. You know, sir, I will be short, sir, because right now, I had an experience years ago, sir. I was flying into Grenada, and I was on a plane, and they announced the approach to the runway, and then minutes later we were still in the air. I looked down and the plane was just circling. And what I came to understand, sir, was that there was a sheep running about loose on the runway. So every time the plane tried to land, they thought they had the sheep, and the sheep ran back across and the plane circled some more. By the time the plane landed, sir, I was in such a hurry to get off that plane that I bolted for the door. So I will try to, in honor of that experience, sir, I will try to be as accurate as I can be with this. Sir, why are we here? Legislation does not exist in a vacuum. We don't amend legislation because we feel like it. Usually where an amendment to legislation comes or a new piece of legislation introduced, it is because a need has arisen that has to be addressed or is sought to be addressed by the amendment or the new piece of legislation. In this instance, sir, the need concerns the backlog situation in our courts. That's the reality. Where we even contemplating judge-alone trials at this point in time is because we have a significant backlog in our courts. It is being accepted by all that our judicial system has served us well up to a certain point. From the time Barbados was settled, we imported the system that already existed in England, and that system was a trial by a jury of your peers, or as the AG more accurately represented that, the philosophy that you should not be convicted other than by a jury of your peers. So we've had that system, but as time progressed, more and more things found their way into the courts by way of legislation as criminal offenses and into the high courts. So the category of things that person can now be tried for or arrested and indicted for has expanded. Our laws are significantly more than they were at independence. New categories start to be introduced as time goes on, as societal norms change, as the need arises. So the ambit and the categories and the expanse of matters and the diversity of matters that now attract the attention of the judge and jury in a criminal trial are significantly expanded from 1966. If we're evolving, then we cannot stay stagnant with the processes that determine the evolution. If our laws suggest trials as being the proper way to assess the guilt or innocence of an accused person, then we have to look at what those trials represent. At the end of the day, the ultimate objective is to give the accused person a fair and speedy trial. He should be tried as quickly as possible, and his trial should be fair. Is the requirement of a jury trial the only way to attract fairness for an accused person or a charged person before the courts? I do not believe so, sir. But we have to also accept that we are dealing with an entrenched system that has, in some effects, served the accused person well. The Honourable Leader of the opposition on a number of occasions said the Attorney General is going to have to come back. He applauds, I'm paraphrasing, he can correct me if I'm wrong, he applauds what was intended by the legislation, but he feels that when it goes into practice, lawyers are going to continue to advise their clients to go to trial by a jury. I don't necessarily see it that way. If we look at the practical operations of our courts, the election exists all now. It is not necessarily by a judge, but the election exists in what we call hybrid offenses, which are actually indictable offenses that can be tried summarily. Where those occur in the legislation, then the option has to be put at the magistrate's court on the first appearance. Do you wish to be tried summarily, or do you wish to be tried on indictment? Now, interestingly, sir, the vast majority of persons who are given the election at the magistrate's court ought to be tried summarily. So persons, when given that option now, it is not an option before a judge whether they want to be tried by the judge alone or by a judge and jury. It is effectively an option that exists at the magistrate's court. Do you wish to be tried before a single judicial officer, which is the magistrate, or do you wish to have your matter sent up for trial and indictment? As it stands now, sir, the majority of persons ought to be tried summarily. You ought to be tried summarily for a number of reasons. You might not want to take the risk with the judge and jury. The fines and the penalties that occur in the magistrate's court might be less. So if the Honourable Leader of the Opposition was thinking in terms of ways that we could possibly amend this or revisit this, it may be in relation to discounts for your option. That might be something to be considered. But as it stands now, where the option exists, the majority of persons ought to be tried by a single judicial officer, which is why you have some measure of confidence that this is going to be taken up. Now, the Honourable Leader of the Opposition and the Attorney General pointed to the fact that, you know what, there's some perceived biases based on the history of prosecution in Barbados. A lot of the judges came up through the ranks of the prosecution and ascended to the bench. And whether or not somebody can park the bulk of their career and their philosophies to put on another hat entirely and let go of certain prejudices which were inherent is a question, can they? When we appoint you a judge, or when you're appointed as a judge, we expect you to be able to. Let us talk reality. Those who practice in the criminal courts know that there's some judges who came up the ranks through the private bar and who are more disposed towards lending a lenient ear in criminal cases, in the adjudication of criminal cases, in their summation of criminal cases, in their directions to the jury, right, in their mannerisms on the bench. Now, I do not believe that attorneys across the board are going to wholeheartedly say, we do not want a trial by judicial officer alone. There are some judges who, based on their record, a lawyer may advise his client, take the chance with this judge. If you are found guilty, they tend to go towards the lower end of the scale. Based on how they've operated in the past, you may stand a good chance with them. What we also have to factor, sir, and we spoke about the Latimer House principles. The Latimer House principles are the principles that inform the independence of the judiciary. That you no longer appoint judges through the political class. It is no longer a sole thing for a prime minister or president or a head of state to have the last word in appointing, well, to have the sole word in appointing judges, that they should be, advertisements should go out. You should seek outside your country as well. You evaluate the applications, you go before a panel, and you pick the best persons for the job, bearing all the other factors in mind. And we have gone through that process for the last set of judicial appointments and the set before that. So our bench is a lot more independent than it previously would have been. The perception of the independence of the bench now stands in good stead based on our method of appointing judges at this present point. So as we proceed, the coming up through the ranks of the prosecutorial class is going to phase out. That perceived bias is going to become a thing of the past. We have to start somewhere with what we plan to do. Sir, as we evolve, we are seeing things creeping in. Once upon a time, when I was initially called to the bar, sir, and you were too, the only reports that we saw of what went on in court were in the Nation and the Advocate. You would open the court pages and you would look in the paper to see what happened in court the day before. That was it. You had reporters who operated in the courts. They knew what to write and how to write it to not appear biased. They gave you certain facts, and they protected in many instances the identity of the persons involved, as much as was possible to ensure fair reporting. We have seen the evolution since then of social media, where persons not just post about what is going on in courts, but persons may take a post or something, a news article that was properly and validly written, and post it, put their slant on it, and then invite comments. And that's where the danger comes in. I saw recently, I'm gonna have to be really vague about this. I saw recently somebody being charged for an offense. It was posted by someone on social media. Their particular post was not necessarily salacious. They reproduced most of what was in the newspaper. But if you look at the comments below the post, the comments below the post tried, convicted the persons, assumed their guilt on previous charges, said that had they been locked up then they would not here be now to commit this offense, right? And they're guilty twice. Now the person has actually not been tried on any of the offenses yet. But if you look, sir, they had hundreds of posts condemning these persons. No. If that person goes to trial and is offered the election between being tried by a judge alone or by a judge and jury, I would bet you that person will pick a judge alone, because they have already been condemned in the public sphere. So every single morning I get up. In morning routine, I get up, make a cup of coffee, and then sit down and read all the publications in Barbados and the Minister of Information. I read all the major newspapers, I read the major blogs, and I read the comments. Sir, 2 hours out of every morning is dedicated to seeing what went on, seeing what was reported, and catching up with it. I have, sir, had on occasion to call the editor of legitimate and popular newspapers and say, please disable your comments under this article. You need to look and see what is being commented on. Because quite often, sir, people post things. You post it and you leave it. You might check it back to see how it's doing. But people generally don't go through every single comment. And sometimes the damage is being done in the comments. But I have had, sir, to contact certain social media influencers and say, you might want to pull down this post, or you might want to disable your comments because you may be sued. Or because if this person goes to trial, their lawyer might have a valid cause to say, well, he can't receive a fair trial because of what was put forward there on social media or under a Nation article. So if we limit ourselves to what existed 20 years ago, we might not see the need for judge-alone trials. As our jurisprudence evolves, as our way of dealing with things and reporting on things evolve, as more and more persons have a say in the public sphere and the sensibilities and emotions of persons can be manipulated by other people, then the need to protect the accused person in a criminal trial now comes to the fore. The Honourable Leader of the Opposition ended when the sheep finally got off the runway and the plane was coming into land. He ended by saying that he hopes that he can see that the Honourable Attorney General will have to revisit this in a short order, and he hopes he has the courage to impose judge-alone trials for certain offences. Now, let us go through the process of this. We are now changing a culture. Judge-alone trials, as I said, existed from the time that Barbados was settled. Sorry, judge and jury trials existed from the time Barbados was settled. There was the feeling as we were considering the legislation to make certain offences trialable by a judge alone. The Honourable Leader of the Opposition picked the easy one: financial crimes. In technical and difficult and complicated financial crimes, sir, quite frankly, a jury will be lost in many instances. If you see jury in fraud trials sometimes and you go and sit down and watch them, right, they tune out. As you're going through the nitty-gritty and the details of it, they tune out. They cannot follow. Sometimes we as lawyers have difficulty following the complexity of those cases. The average person will tune out. So is justice better served by having a jury who may be disinterested and tuning into the wrong parts? Or is it better served by having a judge whose duty is to follow what is going on, render a decision there? That can be subject to an appeal at the end of the day. So there's certain matters, sir, I'm even guessing firearm matters, some certain drug matters that might be better served by a trial by jury, by a judge alone. But this government does not sit here and lord it over people. We have been a consultative government. We have consulted more on legislation than any other government in the history of Barbados. We did the major consultation, sir, on the child protection legislation, the child justice legislation. We went to full consultation on this. We asked everybody who had a part to play in the judicial system. Everybody, all players. And the general feeling was, we hear you. It is a change in philosophy. We are with you, but we will agree to the model that allows the accused person to choose. The bar said clearly, and the criminal attorneys, the criminal bar, said clearly, we're not agreeing to anything that takes away any of the rights of an accused person. If we were to impose legislation that sought to make certain criminal offenses mandatory trialable by a judge alone, then that would lessen the rights. It would derogate the rights of the accused person. What we have done now is say, all right, let's provide options. We have to introduce it. Let's introduce it, get it moving, get it working, and then we can see where it goes and what needs to be done after. So I agree with the Honourable Leader of the Opposition that at some point in time, we may revisit this to tweak it as it gets buy-in, as it starts to operate, as persons see how it's working, as accused persons realize that, you know what, sometimes this is playing out in our favor, and more persons try it. Then we might get the buy-in. But we would be a foolish government where the bulk of the stakeholders have agreed on one course of action that gets the door open for a change in something that existed from the year dot. We would be foolish to impose our will and have those same people who have to use the system come up against us in the first place. The bar is charged with protecting or representing the rights of the individual in a court. The judiciary is charged with securing a fair trial and ensuring a fair trial. If the persons who are charged with protecting the rights of the individual and securing the rights of the individual did not buy into this, we would get nowhere on it. So right now we have a situation where everybody's agreed. The AG spoke about the situation in Trinidad. Trinidad had taken the course that Barbados had done. We sought to introduce the judge-alone trials by election of the accused person. After a while, they said, you know what? Let's make some of them mandatory. Let's create a category of offenses that are mandatorily tried by a judge alone. That backfired in a major way. So when we're looking at our legislation and our amendments to legislation, then we consider our Caribbean neighbors. We look at their legislation. We try to find the best pieces. We pull together from everywhere so that we can share in the experience and benefit from the experiences of our fellow Caribbean neighbors. It is not just in drafting the legislation, it's also in monitoring the experiences and the usages of the new legislation. When we saw what transpired in Trinidad, and we coupled that with the representation by the bar in Barbados and by the stakeholders in Barbados, sir, then we had to, for the purpose of introducing this legislation, introduce it gently at first and let it run, let people get accustomed to it. Let's see how it works. Let's get feedback down the line and see if any tweaks or amendments have to be done, right, in a proper consultative way. But sir, I started by saying that legislative amendment happens for a reason. And the reason here was the backlog. We are never going to remove the backlog unless we undertake radical change. We cannot remove the backlog by running through full trials on all criminal offenses. It will never happen. More people are getting charged than trials are being done. Every day, I don't have the figures, but I'm guessing. Let's put a figure. At least 15 people get charged a day. I'm saying at least. On a Monday, it's a lot more than that. At least 15 people get charged a day. How many trials do we do in a day in Barbados? 4? 3? The sheer mathematics of it says that every single day we are falling further and further behind. We are not going to remove or reduce the backlog unless we take a radical change. Sir, I smile because sometimes you have to let some things go. I have seen in some courts now judges saying, look, this trial has been on too long. There's no real victim in it. The length of time that this person has been charged on a waiting trial makes it unfair to try them, and some of the cases are going out. That is one way, and it had to happen. It had to happen. But sir, you're going to have to look at some trials as well, where there is no victim. Instead of a journey in perpetuity, knowing that you cannot actually secure a conviction against an accused man, sometimes the prosecution is going to have to be bold enough to say, we wish to withdraw this. Sometimes the judge is going to have to be bold enough to say, we can't properly try this. Unless we do that, we're going to keep putting matters into rotation that have no possibility of resolution. So I'm not going to say go as far as one judicial officer. There was a judicial officer, sir, that we all know, who I remember clearly as a young attorney. I went to his court. And it was I was ruining the fact that I had to be at court on the first day of a test match. And I went to court. We got a notice saying that court was starting early. And sir, the judicial officer came in. And he said, look, everybody who intends to plead guilty, go on the left side of the court. everybody who intends to plead not guilty go on the right side of the court. For all of a certain kind of matter, you will get a reprimand and discharge if you plead guilty today. I sat down in stunned amazement. I, sir, was planning on defending my client down to the hilt. And I said to him, if you're getting a reprimand and discharge, I would suggest that you plead guilty and let's get out of here. And that was done, sir, so that judicial officer could get to Kensington in time for the first ball. But
He got there at 5 minutes to 10.
we all know who it is,
So
yes,
it
sir.
started at 10
We
o'clock.
all know who it is.
9 o'clock, court commenced.
But one person who was guilty of a sexual offense actually went to go with the guilty part, and he said, no, not you. So it means something, but for all the small things, all the little drugs, all the whatever, everybody that day got a blind. The court was done. That whole docket was wiped out in one. No, I'm not saying that we need to go that far, but I am saying, sir, that we need to exercise our minds as to how can we do this, bearing in mind we're never going to get it done by trials alone. Sir, I just want to touch on certain salient points of the legislation itself. Section 3, sir. Every person against whom a bill of indictment has been preferred shall, subject to provision of this act, be tried by a judge sitting with a jury, unless he elects to be tried by a judge sitting alone. Now, the Honourable Leader of the Opposition raised some concerns, sir, over clause 3(1)(c). 3(1)(c), sir. In the case of a joint trial, the court shall not make an order for trial by a judge sitting alone unless it's satisfied, in the case of a joint trial, that all other accused persons have elected to be tried by a judge sitting alone, and each accused person has filled out a certificate set out in Form A or B of the first schedule. Now, sir, where the person elects, the judge still has to make the order. So this plainly says, and it makes sense, if four persons are tried together, and one person says, I want to be tried by a judge alone, and the other three say, I want to be tried by a jury, sir, then the judge cannot make the order for that one person to be tried alone. If it's a case that of necessity requires the four people to be tried together, then the order is made for trial by a judge and jury. He has not lost anything, any right that he didn't previously have. Technically speaking, sir, I am sure that at some point in time somebody's going to contest it, and then the appeal court or maybe CCJ will make a decision on that, right, as to the constitutionality or the fairness of the person. But practically and commonsensically, sir, then if one out of four says, I wish to be tried, or I put it another way, necessarily for the case to proceed with the four persons, all have to agree to be tried in the same way, logistically and practically. Sorry, sir. Logistically and practically, it makes no sense to actually separate the modes of trial. Actually, it cannot possibly be done. All have to be tried either by a judge alone or by a judge and jury. Sir, there's protection built in here where every person who elects to be tried by a judge alone has to prove that they actually understand what it is they're doing. They understand that they're giving up their right to jury trial. They have to certify that, they've had advice from an attorney. If they haven't had advice from an attorney, then the judge needs to be comfortable that the person is competent to actually understand what is going on, understand what the difference is between a trial by a judge and jury, right? And the difference between that and a judge alone, and that the person can make an informed decision. Where that is done, sir, as you said, as somebody said, right? We've had people who defended themselves, Sylvan Woggy Clark. Woggy Clark, people used to go and sit down in court to hear Woggy Clark defend himself. Woggy Clark used to cross-examine police better than a lot of lawyers. He was cite precedent and be holding court. There are certain people in Barbados, sir, who are quite capable of making that election themselves. But the judge will only do that and make that order for a judge alone trial if he is sure that the person understands what is going on. The other thing, sir, in speeding up, I agree with Mr. Thorne Sir, I agree with the Honourable Leader of Opposition in a way that sometimes the summations take too long, right? They actually take quite a long. There are many ways that we could deal with that, sir. Quite frankly, you can give the jury transcripts as well, cutting out the parts that they're not supposed to see so that they have the evidence to refer to. I mean, as we go along, it is going to develop. But I do believe that a lone trial eliminates a lot of the delays inherent in a trial with a jury, the voir dires, where you have to excuse the jury to hear certain technical legal points that they're not supposed to hear that might confuse them or that might prejudice their assessment of the evidence going forward. These occur in almost every case. All these serious cases of voir dire comes up maybe once, twice, or a couple times in the course of the trial. So a judge is able to hear everything and exclude. He's trained and exclude what he does not have to hear. So the judge alone trials make it a lot cleaner, tidier, and speedier. But however, we are saying, if it is your wish and you're comfortable with it, you have the right to be tried by the jury and endure the long trial if you so desire. And the other protection is that where the judge, when a jury says not guilty or guilty, the jury doesn't have to give a reason. The jury says not guilty or guilty and goes on with their business. If it's a judge alone trial, sir, there's a built-in protection that on a finding of guilty that the judge has to give a written decision. That allows the lawyers to find out exactly what went on there and provide more grounds for appeal for them if they wish to appeal. So there are built-in protections, sir, into this legislation that I am comfortable that the accused man ends up with more options and is better protected than before this legislation. The last point of this legislation I actually wish to draw to people's attention, the reason that the election does not exist for treason, for high treason. High treason, sir, is still punishable mandatorily by death. And the practice is that you don't sentence a man, you don't try a man on something where the mandatory sentence is death unless he is tried by a jury of his peers. So because the mandatory sentence for high treason still is the death penalty, then that one had to be taken out from a judge alone trial, so they still have the complete protection of a jury, of their peers, as they would have for capital murder. So, sir, I believe that we're in good stead. I believe that we are moving with the times. More things are going to come. As I said, we can't get there by doing trials. We're never going to wipe it out by trying everybody. The Attorney General has advised that plea bargaining legislation will be coming very shortly. I can't speak on that until it comes, but what I will say is that is in keeping with the ethos that we have to consider all of the options that lend to a speedy disposition of cases other than through a full trial. And I'm comfortable. I must commend the Honourable Attorney General, sir. As an AG, he takes a lot of, the position of the AG will necessarily take a lot of flack, right? Because it is not one that wins popularity votes, right? A Minister of Housing, sir, can help people with houses. A Minister of Public Works can give away some jobs. The Attorney General's ministry, sir, is not one that lends itself towards endearing them to the public of Barbados. Sir, can say that I don't think there has been a more productive Attorney General with respect to the proliferation of legislation that has been coming down the pipe, especially those to radically transform our justice system in Barbados. And we can clap for that. We've gone from 2 criminal judges to 8 criminal judges. We've gone from, I think, 8 judges in total to about 15 or 16 judicial officers now. We've gone from the Court of Appeal, sir, is at its fullest complement when the next set of judges are appointed to the Court of Appeal, right? We have never had this much put into the administration of justice as we've had in this term. So I wish to commend the AG. I wish to say that this piece of legislation is in keeping with what he has set out to do and made it his mission to reform our judicial system and make it the envy of the Caribbean. We are not there yet, but enough is coming. That if those, sir, who are stakeholders are prepared to give the legislation a chance to work, then we're going to reap the benefits down the line. The very last point I wish to make, and just because I'm sticking it in, when we think about persons who may benefit as well from judge-alone trials, not just talking about the social media hype, sir, but persons who have had multiple highly publicized charges. If you appeared charged for an offense and you end up in the paper in handcuffs, and then you appear charged for another offense, end up in handcuffs, then the public of Barbados judges you and assume that you were validly charged in the first place. And there is a bias on the part of a lot of Bajans, sir, that wants the police ain't gonna charge you unless there's something there. But if we go with the most fundamental precept of our jurisprudence and our judicial system, that a man is innocent until proven guilty, then that man should be given every single opportunity to defend himself in the best possible way. And the latest round of that is to give him an option as to whether he wishes to be tried by a judge and a jury of his peers, or whether he wishes to be tried by a judge alone. So having said all of that, sir, it is clear, it is apparent, sir, that the ship is now off the runway. The plane can now land, and the captain announces that I land fully in support of this legislation. I thank you, sir.
Honourable Member for St. Joseph.
Mr. Speaker, I don't have much to say. I'm grateful for the support of the Chamber on this bill. I think we are mindful that on many occasions Parliament will pass a law and there may be no immediate application of it. But over time, as individuals become more and more familiar with it, more attuned to the prospects, we see it being used. I'm looking at a piece of legislation now, sir, that was passed in St. Vincent in 2013. The first time it was used was 2023, 10 years later, but used to important effect. We are passing this legislation at this point in time. I am not a skeptic. I hope that individuals will use the legislation. There's no compulsion, but the important thing, sir, is that it is available to accused persons and their counsel to consider as an option. The one matter I want to respond to, though, is the interpretation given by the Leader of the Opposition to the clause, which is at clause 3 of the bill, which amends section 7 of the Principal Act, and in that regard talks about section 1C. The factual matrix that the Leader of the Opposition considered, which is what is here, is if you have 4 individuals charged jointly, one of them says, I want a judge-alone trial, and the other 3 say they want jury trials. The Leader of the Opposition seems to have formed a view that this circumstance will cause the system to gum up and nothing happens. But I'd like the Honourable Member for Christchurch South to take a look at the legislation closely. I fear, and he has accused me of being timid. I'm not timid enough to say that he misunderstands the legislation. Mr. Speaker, the bill says every person against whom a bill of indictment has been preferred shall be tried by a judge sitting with a jury unless he elects otherwise. So your default position is that you shall be tried by a judge with a jury. We've given you the right to elect otherwise. But what happens when you have 4 people and one says they want a judge-alone trial? It's right there, sir. But I don't think the honourable member has studied it. He did see you when you look at the bill this morning. Mr. Speaker, it says, the court shall not make an order for a trial by judge sitting alone. That's what it says. The court shall not make an order for a trial by judge sitting alone unless it's satisfied that all of them elected. So the point is, sir, if you have more than one individual, and one person says, I want judge alone, the other one says, no, I want judge and jury, the court cannot order judge alone. That is what the court cannot do. So the default position of judge and jury is what obtains. It's as plain as day to me. I hope that the Honourable Member for Christchurch South will understand it. So Section 1C says the court shall not, because remember you can only get a judge alone trial if the court orders it. The court doesn't have to order trial with judge and jury because that is the grand norm. That is the basic norm. That is the rule. So there's no need to make an order with respect to the rule. The only thing the court has to make an order for is if it is to be a judge alone trial. And this section says if all do not agree, the court shall not make an order for judge alone trial. And therefore, sir, the trial defaults to a judge and jury. No. To me, it is as plain as day. Because, I think the provision quite clearly says what the power of the judge is and when he can exercise the power. The judge can only exercise the power to order a judge alone trial if all agree. If they don't all agree, sir, the judge is not to sit on his hands and say, well, I don't know what to do. He does what the Act says. It says every person shall have a trial by judge and jury. That's the default position. That's the norm, sir. You only deviate from the norm in the presence of an order to do so. So I think this is quite clear. I understand the Honourable Member may have looked at it a bit differently in the early hours of the morning, but I hope that as the day has cleared up, sir, it'll become clearer for him. But I don't think this is an issue. And with that, sir, I beg to move this bill be read a second time.
Question is that the bill be read a second time. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that the House do resolve itself into committee for further consideration of this bill.
Beg second that.
That you do not leave, implicit in that, sir, is that you leave the chair because you can't sit in committee.
The question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honourable members in favor, please say aye. Those against, please say no. We think the ayes have it.
Which order that is in? That should be easy.
This House is now in committee.
Clause 1.
Mr. Chairman, I beg to move that Clause 1 stand part.
Beg second.
The question is that Clause 1 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that Clause 2 stand part.
Beg second that.
Question is that Clause 2 stand apart. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 3.
Mr. Chairman, I beg to move that Clause 3 stand part.
Beg second that.
The question is that Clause 3 stand apart. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 4.
Mr. Chairman, I beg to move that Clause 4 stand part.
Beg second that.
The question is that Clause 4 stand apart. All honourable members in favour, please say aye. Honourable members against, you say no. Methinks the ayes have it.
Clause 5.
I beg to move, Mr. Chairman, that Clause 5 stand part.
Beg second that.
The question is that Clause 5 stand apart. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 6.
Mr. Chairman, I beg to move that Clause 6 stand part.
Beg second that.
The question is that Clause 6 stand apart. All honourable members in favour, say aye.
Honourable members against, please say no. Methinks the ayes have it.
Clause 7.
Mr. Chairman, I beg to move that clause 7 stand part.
Beg to second that.
The question is that clause 7 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 8.
Mr. Chairman, I beg to move that clause 8 stand part.
Beg to second that.
The question is that clause 8 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 9.
Mr. Chairman, I beg to move that clause 9 stand part.
Beg to second that.
The question is that clause 9 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Clause 10.
Mr. Chairman, I beg to move that clause 10 stand part.
Beg to second that.
The question is that clause 10 stand part. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
First schedule.
Mr. Chairman, I beg to move that the first schedule be the first schedule to the bill.
Beg to second that.
The question is that the first schedule be the first schedule to the bill. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The second schedule.
Mr. Chairman, I beg to move that the second schedule be the second schedule to the bill.
Beg to second that.
The question is that the second schedule be the second schedule to the bill. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
Mr. Chairman, I beg to move that you do now report to His Honour the Speaker the passing of one bill in committee.
Beg to second that.
The question is that I do now report to His Honour the Speaker the passing of one bill in committee. All honourable members in favour, say aye. Honourable members against, say no. Methinks the ayes have it.
The chairman of committees is reporting the passing of one bill in committee. Honourable St. Joseph. Read. No, be read a third time.
Beg to second that.
The question that the bill be read a third time. All those honourable members in favour, please say aye. Those against it, please say no. We think the ayes have it.
Mr. Speaker, I beg to move that this bill do now pass and be cited the Criminal Procedure Amendment Act 2024.
Beg to second that.
The question is that this bill be passed and so cited. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This bill is passed and so cited.
Thank you, Mrs.
Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move the suspension of the House until 2:15 p.m.
The question is that this honourable chairman be suspended until 2:15 p.m. All those honourable members in favour, please say aye. Those against, please say no. We think the ayes have it. This honourable chairman stands suspended until 2:15 p.m.